Is your name now? All right, you're open, bud. You just leave right there, bud. Come sit over here for me.
Are we ready?
I believe so. Good morning. All right. Yeah, you can just have a seat right there for me, bud. I'm gonna try and line up your face with.
All right, good morning. It's Maryland Pro. We're called to order. It's Thursday, February 5th, 2026, and it is 8:43 a.m. My name is Cheryl Renatza, serving as chair of today's parole panel. Seated on the panel today with me is Mr. Chucky Tillis, Mr. Steve Prater, and we are in Baton Rouge at DOC headquarters. So would the staff here introduce themselves, please?
Jason Thompson.
Jason Cavalier.
All right, and our first remote location is at St. Tammany Parish Jail. Good morning, St. Tammany.
Good morning.
Good
Is
morning.
would the officer please introduce yourself for the record?
Sorry, bud.
Not a
My
problem.
name is Lieutenant Todd Carson.
Thank you, Lieutenant. Thanks for accommodating us this morning.
Yes, ma'am. Thank you.
And Mr. Orange, good morning, sir.
Good morning.
Would you introduce yourself? Tell us your name and DOC number.
Vernon Orange, 180943.
All right, Mr. Orange, do you have any paperwork there with you?
No, ma'am. I just have notes on what I wanted to say.
Okay, I'm gonna, are you ready to proceed without a lawyer this morning?
I was denied. I asked for counsel and was denied, but I'm ready to proceed, ma'am. It's not.
So based on that, you filled out that paperwork, and based on the information contained in that form, you're not eligible for an appointed lawyer, but you could retain a lawyer should you choose to do so.
I understood that, ma'am. There's no problem with that. I'm not contesting that that's a problem.
Okay, so you're ready to proceed this morning.
Yes, ma'am.
All right, your case was assigned to me, so what I'm gonna do is read the allegations against you, and you'll enter a plea of guilty or not guilty, and then we'll go from there.
I'm familiar with the file, ma'am, if you want to spare the time. I know that, you know, my residence changed without the parole officer's permission, but I did have a lengthy statement I wanted to give you ahead of time.
You do the statement, once we have to enter your plea, and then we'll
Okay,
talk
go
about
ahead.
your
I'm sorry.
statement. So the first one is condition number 3, which says, on October 24th, 2024, the parole board voted to add conditions of residing at 516 Erlanger Avenue in Sliding, and have GPS ankle monitor fitted at your expense after you were released from a previous sanction After that release, you failed to report to the Office of Probation and Parole, failed to live at that address, and failed to have the GPS monitor installed as you were instructed. After several failed attempts to make contact were made, a warrant was subsequently requested and granted, issued by the board April 23rd, 2025. You were arrested on that warrant in Jefferson Parish, November 7th, 2025. So how do you plead to violating condition number 3?
I wasn't at the residence, so I have to plead guilty, but
Okay,
I'm
you
gonna
can
be allowed
tell
to-
me about it in a minute. I'm going to go through all the allegations first. Number 7 is rule number 7, condition number 7. I will truthfully and promptly answer all questions directed to me by my parole officer. You failed to obey this condition of supervision when you absconded from your supervised parole. How do you plead to violating condition number 7?
I don't actually know how to plead to that because I've never been allowed to talk to the man, and due to what happened, I guess I have to plead guilty to that because I wasn't able to speak to him. I've never denied not answering any of his questions, though.
All right. Condition number 9 says, I will agree to visits at my residence or place of employment by my parole officer at any time. I agree to searches of my person, property, residence, and or vehicle when reasonable suspicion exists that I am or have been engaged in criminal activity. You failed to obey this condition of supervision when you absconded from your supervised parole. After several failed attempts were made to contact you, a warrant was issued by the board. So how do you plead to violating condition number 9?
Because I wasn't at the residence, I don't have any choice but to say guilty, but I'm not guilty of all of that.
Condition number 10, you have an arrearage of $309. Your last payment was posted November 6th of 2025. So how do you plead to that?
I wasn't in arrears at all, ma'am, till I got put in here and can't pay it. And I'll be glad I've made my payments for 10 years.
Right, so you plead
So
not
not
guilty.
guilty.
Okay. Lastly is condition number 13, which was a special condition. And that was the GPS monitoring at your expense and residing at the residence in Slidell with your daughter.
Guilty with a statement.
Okay. All right, go ahead and read us your statement.
I did my time at Angola, as I'm sure you know. I did 20 years flat and was released. During my time at Angola, I only had one DB report. I worked for Warden Stagg and Miss Trish Foster for 15 years. I completed risk assessment with a low risk. I became an instructor and certified GED instructor and literacy instructor. I completed 100 hours, completed substance abuse 1 and 2, anger management, marriage counseling, parenting. I did reentry seminars and completed my mentor training and became an instructor in the reentry program. I'm an associate minister with the Word of Faith. I was a HIV, AIDS, hepatitis instructor certified by the Red Cross and the CDC, and I got 3 associate's degrees, the last of which was LSU's law school in 2015. I would not, under any circumstances, have committed another crime or put myself back into the custody of the department after working so hard to do what I did. I've been out for 10 years, ma'am. I'm going to be 71 years old in May. I'm on 9 different medications. I had a stroke, and I'm still on the medications for that. As far as the severity of my conviction, I understand that, but it was 30 years plus ago that it occurred. I've been a supportive and law-abiding citizen to the best of my ability without committing. I haven't even gotten a traffic violation in 10 years. And I'm scared to death of having, to commit another crime. I wouldn't do that. That's why I was going to ask Warden Stagg and Miss Foster to come and testify on my behalf, but I couldn't get them because they didn't give me notice of this hearing until 3 days ago.
All right, so all your time in prison is irrelevant to what's going on today. Tell us why your last contact
Yes, ma'am.
with the parole officer I saw was, let's see, I guess this was the last, was November 23rd at a Harbor Drive address in Slidell.
I was not at that residence. I attended a wedding as a matter of fact, I was the minister at the wedding. This was a day and a half after I was released, and I knew to go get the ankle monitor, but my daughter pulled the residence address on that day and left me homeless. And I was stuck in Metairie, didn't know where to go, what to do. I have an anxiety disorder and PTSD, and I guess I was just overwhelmed, but she pulled the address. I didn't have anything to do with that. And although it's not an excuse, ma'am, I'm not trying to give you excuses. I'm just trying to tell you what happened. I wouldn't commit another offense, and I wouldn't have done what's done other than being overwhelmed. I had the stroke, and worst of all, not that it means anything to the committee, but I'm hoping you'll at least hear it. My son hacked into my account, stole all my money, which was over $4,000, rerouted my Social Security, and he was going to do that to me again. I was completely overwhelmed by all of this. And all I can do is beg the committee's indulgence based on my record and everything else to please place me back on parole. I'll do whatever you need me to do, wear a wrist bracelet. It's supposedly cheaper. I don't have the money to that's been the problem trying to find residents.
Mr. Orange. So you said you were overwhelmed. Why did you not reach out to your parole officer?
Other than I was overwhelmed and dealing with the things with my son and being brokenhearted from what my daughter and my son both did, I don't really have an excuse that would excuse my behavior, ma'am. I have an anxiety.
Why did daughter pull the residence? Why did daughter pull the residence and say you're no longer welcome there? There's a reason.
She was angry as all get go because I went back to my son's place to try and get my property, the remainder of it, because I lost everything I owned in my storage unit because he took off with the money and I couldn't pay it. That's why that happened. She got mad, and I've talked to her since. I understand that she was mad, but I don't believe that she knew what she was doing when she pulled that residence address and left me stranded.
Well, you went through all this before and were sanctioned, and then after the sanction, you were given another opportunity for the GPS and, you know, the new residents and all that. I don't understand. You know the rules. You understand completely how important it is to follow the conditions.
Yes, ma'am, I do. That's why I said I'm not trying to give you an excuse. I was overwhelmed. I had my son doing the same thing to me again. He called in right when I was fixing to try and contact my PO. My son had me put back in here, took off with my wallet, my keys, and he was going to do the same thing again. And I guess that I'm stupid for trying to make amends with him and believe him. But that's all I can tell you is that I was completely overwhelmed. I got in a motorcycle accident. I broke 7 ribs. I was hospitalized for 10 days, fractured my sternum.
Mr. Orange.
I don't have any.
I'm sorry about all that, but that's irrelevant to today. Now, on your parole revocation questionnaire, you indicate that you receive a disability check.
Yes, ma'am. And I've paid
$6,850.
Ma'am?
$6,850.
What's $6,850?
That's what you put on your questionnaire, that you receive $6,850 a month in disability.
That is incorrect. I don't know why that's there. I get 19.
Sign that form.
I don't ever remember seeing that at all, ma'am. I wouldn't lie about that. I only get 19 something. I don't get it. I don't know why that's there. I do not receive that much. If I received that much, I'd have had a residence a long time ago. And I do have my residence now. It's in Metairie. I was requesting a transfer and the landlord's waiting for me to come back and get it.
Why were you arrested? What were you doing in Jefferson Parish when you were arrested?
That's where I found the apartment I got. And I was working what little I can do. I was doing some painting, trying to earn a few extra dollars, but I was there because that's where I found a place. I could not find one in St. Tammany for less than $1,200.
All right. I don't have any other questions.
So that's where you will live, the address you just gave, if you were released?
Yes, sir, that's where I was. And prior to getting with my PO, my son had me put in here and ran off with my money and wallet and everything again.
How will you get to pay for the ankle bracelet?
Well, I was hoping that you could give me a wrist bracelet, which I understand is $68. That's about all I can afford, but I'm willing to pay it and do whatever the board sees fit for me to do to prove myself. I'm not going to commit another crime, and I won't let this happen to me again. I got my own place now, and I don't have to rely on daughter, son, or anyone else. This is my place alone.
Okay, I have no questions.
Great. All right, Mr. Orange, I don't see that we have any other questions, and I'm prepared to vote. And I don't believe you had any intention of reporting. I have the information in the record of really what happened. My vote today is going to be to revoke your parole. I hope that you're able to get the medical attention that you need and take some time to get your life back in order. You'll have an opportunity to reapply for another parole, but I'm not willing to do that today. Mr. Tillis?
I concur with Ms. Renata.
Mr. Prater? All right, Mr. Orange, I wish you well. Good luck.
Okay, thank you. Put your chair up, son, so they can come in. Both of us. Desiree or Desiree? Right, that's great. Well, I don't see her, well, they might not let her in yet if she's on the app.
Good morning.
Good morning, can you hear us?
And
Okay.
we are at TANGIPAHOA Parish Jail, is that right?
That's correct.
And we have before us Mr. Brown. Good morning.
Good morning.
Would you introduce yourself? Tell us your name and DOC number.
My name is MARLYN BROWN, DLC number 581224.
See, you have counsel with you this morning. Ma'am, would you introduce yourself? Record.
Yes, good morning. Attorney Erica D. Williams, and my bar roll number is 27326.
Thank you very much. Mr. Brown, you're here for a revocation decision this morning. So I'm going to read the allegation, ask you to enter your plea of guilty or not guilty, and then you and or your lawyer can tell us what happened. Okay? Ready?
Yes, ma'am.
All right. You're accused of violating condition number 4, and that states records reflect you were engaged in criminal conduct on August 24, 2025, which led to your arrest by the Hammond City Police Department and subsequent charge of domestic abuse, second-degree battery. On November 10th, 2025, the charges were amended to domestic abuse battery. You pled no contest, and you were sentenced to 6 months parish jail. How do you plead to violating condition number 4?
Guilty.
You say guilty?
Not guilty.
Not guilty. Okay. All right. So tell us about it. And Ms. Williams, you can jump in anytime.
Okay, I'll speak first, and then if you all have any follow-up questions for him, you can. I was the counsel, again, for the record, Erica D. Williams, bar roll number 27326. I was the attorney of record for Mr. Brown on the charge that you indicated a no contest plea was entered into. Upon reviewing the discovery and talking to the prosecutor, my client did agree to enter a best interest no contest plea. The main reason for that, excuse me, is that in our jurisdiction, if he were to actually go to trial on that felony, and again, this no contest plea was in 2025, the earliest we could have gotten a trial date was sometime in 2026, and not even the early part of that. Again, that's just based on the judge's calendars for trials. After review of this discovery and meeting with the prosecutor, and then also I provided the state with a copy of a sworn affidavit from the alleged victim. Based on that, the DA agreed to amend the charge to a misdemeanor so that my client could plea. Miss Desiree Cornish is the alleged victim. I don't know if she's in the waiting room. She had indicated to my office that she may participate this morning. She may give a better insight as to what actually occurred on that date, but my client would like to explain to you all what happened. The other thing is we are here today, and I'm here specifically on his behalf to just kind of make the board aware of an unfortunate circumstance that recently took place approximately 2 weeks ago, where his younger sister was involved in a fatal car accident. That funeral is scheduled for this Saturday. I've been able to confirm that with the mother as well as the funeral home. So, again, we're hoping for a positive result today, but in addition to what this hearing is for, is also to serve as a request that he be allowed to attend that funeral on Saturday. So I'm here kind of twofold for 2 different reasons. But at this time, I'll let my client speak as to the day in question.
Okay, thank you. And Ms. Korish has not checked in with us this morning as of yet. So
You have a copy of her
we
statement
do.
that was previously given. Okay, all right, thank you.
Okay, Mr. Brown, tell us what happened, because I'll say this, because we do see where she had some injuries. What happened?
I don't really know, like, when I pulled up over there, we had got into it or whatever, but it was never nothing violent. Like, whatever had to occur, that was before I was even there. I had came over there by my child or whatever, and we went to Oregon and went to Wood, and then they called the police. I went to jail. When I came to jail, I was charged with, at first I didn't know what I was charged with because I really just came to jail. So when they came, they put a charge on me. Then the next day it was a report, and we'll do it, but I still ain't know what was going on or whatever. But like she said, due to it was a 2nd-degree battery, then they enhanced the charge to a misdemeanor. So I took the misdemeanor, so I wouldn't get the conviction of a higher charge.
Okay. And I can tell you based on my conversation, and again, this is going to be hearsay, but I would like to say, because it did not come from the victim, but I did kind of do my own little investigation. This incident happened, I believe, after midnight. It was brought to my attention, and I did bring it to the DA's attention, that the alleged victim for him was also involved in an altercation immediately before that at a club. Their argument, there being my client and her, stemmed from, they have at the time, I think the baby was 3 months old, and he found out that she was at the club and had left the child at home with her 12-year-old. But from my understanding, that's what their argument was about, but it did not become physical in nature, but she had already sustained those injuries prior to him coming in contact with her. Again, it's hearsay. That's what I was told, and based on some research I did about the club itself, and that was some additional information provided to the state that resulted in them amending the charge.
Great. Thank you. Any questions?
No.
Mr. Brown, no, I realize that you pled to a misdemeanor, but anytime you would think that would be a technical violation of your parole conditions, but anytime it rises to the level of a crime against a person, which in this case it was, and you pled guilty. I understand what your lawyer said, a best interest plea. You pled guilty to the domestic abuse battery. My vote today is going to be to revoke your parole based on that, because I find you guilty of criminal activity and violating condition number 4. Mr. Tillis?
My vote also is revoke for conditions number 4.
I concur.
All right, so Mr. Brown, today, parole's being revoked. I will make a note about your request about the funeral and my condolences about the loss of your sister.
Okay. As it relates to that, is that something that we can because I have it with me here and about the funeral. Is that something that we could provide to his parole officer, who's Mr. Mike Smith, for consideration as to whether or not he would be allowed to attend that funeral on Saturday?
I think that's up to the jail officials.
Okay, when I spoke to the jail officials, they indicated that they can provide it. However, because he is DOC would have to also be in agreement with that transport to the funeral.
Well, we can do that, yeah, but I would advise his parole officer if you can. We'll do it on our end as well.
Okay, thank you.
All right, we're gonna sign off. It is 9:12 a.m. All right, good morning. We're now at Franklin Parish Detention Center and we have Mr. Brass. Is that you?
Yes, ma'am, it is.
Would you introduce yourself? Tell us your name and DOC number, please.
Yes, ma'am. My name is EPHROM BRASS, DOC number 703-115.
And we are here today for a revocation decision. You have your any paperwork there with you, sir?
Just the paperwork that I just received that they wanted me to bring.
Yeah, is that a parole revocation questionnaire, I think?
Yes, ma'am.
That's your signature at the bottom of that page.
Yes, ma'am, it is.
Okay, thank you. Based on that information, you're not eligible for an appointed counsel. Did you hire an attorney?
Yes, ma'am.
Do you expect that attorney to be here today?
I don't know if he has gotten word that I have this revocation hearing.
Because I made a note on my paper that you did have an attorney. I didn't write his name down. What's his name?
Yes, ma'am. Mr. Lavelle Solomon.
Well, do you want to continue this process until Mr. Lavelle Solomon can be present?
Yes, ma'am.
Okay,
Meaning, do I want to wait until he's present?
yes.
Yes,
That's what
ma'am. That's what I would like to do.
Okay, let me see if we have his contact information. Was he present at your preliminary hearing?
No, ma'am.
And you had your preliminary hearing without Mr. Solomon?
This is my first time.
No, because during your
Okay, when I
preliminary hearing, you signed that piece of paper.
he wasn't present with me.
Let me see if I can get to that. But you're saying you want to contact him and what you when's the last time you talked to him?
I haven't spoken with him.
But you have retained him?
Yes, ma'am.
When?
Like maybe 3 days ago, maybe.
But not for this matter. You retained him for the matter, the issues you have pending in court.
With everything I have going on.
All right, well, we're gonna give you a chance to contact him
Yes, ma'am.
and he has to call us
Yes, ma'am.
and we'll reschedule this proceeding.
Yes, ma'am.
All right, you'll stay in jail till that happens.
Yes, ma'am.
All right, so my vote today is to continue so that his retained attorney can be present. Mr. Tillman?
I concur.
Mr. Prater? All right, sir, you need to go call Mr. Solomon
Yes,
or
ma'am.
contact him somehow. Good luck.
Thank you.
All right, good morning. The Committee on Parole is now at the Terrebonne Parish Detention Center. Good morning, Mr. Lacoste. Your mic's on mute.
Yes.
There you go.
Good morning, Mr. Nata. How are you today?
I'm good. Thanks for asking. Would you tell us your name and DOC number?
My name is Leopold Charles Lacoste II. My DOC number is 478688.
All right, thank you, sir. And I see you have counsel with you this morning. You have, I'll let you all, Ms. King, would you introduce yourself first?
Good morning, Teresa King here on behalf of Mr. Lacoste. We refer to him as Chuck. That's his nickname, but I am counsel of record here on the pending charges in Terrebonne Parish, as well as for the purposes of this parole revocation hearing.
Okay, and we also have Miss, is it Lizzie King?
That's correct, Your Honor. Elizabeth King, I go by Lizzie. I too am one of Mr. Lacoste's attorneys. I work with Teresa King, and we represent him in Terrebonne Parish and for purposes of this parole hearing.
Okay, great, thank you. Yeah, so we are here for a revocation decision this morning. Mr. Lacoste, your case has been assigned to Mr. Tillis, so he'll read the allegations and ask for your plea, and then we'll proceed from there. Mr. Tillis.
Mr. Nata,
Yeah.
it was to my understanding that this was being continued for us to be able to get people that I was supposed to have people here on my behalf and whatnot. And according to the paperwork that I was given, and when I'd spoken to my attorney over a month ago, this was, we were supposed to be requesting a continuance on this hearing for us to gather the information that we needed to proceed with this particular event.
I have no information in my records requesting a continuance. Ms. Teresa King, have you submitted anything?
No, ma'am, we were recently hired to represent him on the parole matter, although we did speak to him about it and attended the preliminary hearing at the jail. Miss Allison Leeret had informed us that a continuance was not likely because the parole board wanted to move forward. And then the latest information that I received before I was hired was that Mr. Lacoste had requested a continuance in writing directly. So I don't know if anything was submitted by Mr. Lacoste prior to us being hired.
Well, I think we have enough information to proceed this morning, Mr. Lacoste. So I'm going to go ahead and turn it over to Mr. Tillis.
Okay, good morning, Mr. Lacoste. How are you?
Good morning, Mr. Tillis. Good morning, sir.
We have some violations that I'm going to read. You can plead guilty, not guilty, or with a statement. Violation number 3, you left the state of Louisiana without a written permission from your parole officer as evident of a tax documentation. Certain gambling winnings from the Golden Nugget Casino located at 151 Beacon Boulevard, Biloxi, Mississippi, dated 4/11/2025, and bank transactions on the following dates: 8/11/2024, 9/7/2024, 11/23/2024, 1/3/2025, 1/19/2025, 2/2/2025, 2/2/2025, 3/20/2025, 2/18/2025, 2/27/2025, and 4/11/2025. On or about 4/14/2025, you were engaged in criminal-like conduct as evident by your arrest by the Terrebonne Parish Sheriff's Office on charges of violations of protective order, charges of a violation of protective order, theft of $25,000 or more, felony, and exploitation of the infirmed, a felony. the current charges, loading of this infirm $25,000 or more,
Unbelievable.
violation of a protective order in Terrebonne Parish. How do you plead? Guilty, not guilty, or guilty with the statement?
Well, to which, I mean, to which portion of what you read, Mr. Tillis, is,
If I may, Mr. Tillis, Mr. Lacoste and I discussed at length that there are mitigating factors to explain the technical violation of leaving the state without written permission. And so he may want to admit to those allegations, however, plead not guilty to the new criminal charges of theft or exploitation of the infirm and violation of a protective order.
Okay, you want to explain it or talk about it?
Yes, please. And Chuck, just give me a minute to give an overview, and then you will have the opportunity to provide specifics. So with regard to the allegations that he was leaving the state without written permission, he was previously supervised by a parole officer who gave him leeway. He had written permission to leave to go see his mother, who lives on the Gulf Coast of Mississippi, and went to see her multiple times with permission of the parole officer. The parole officer told him, "You don't have to ask for written permission every time. I know you're coming back. It's all good." Then he got a new parole officer, Allison Liebert, who was much more strict, black and white, with her following of the rules, and you need to get written permission every time you leave the state. And the summary and recommendation that was submitted by Ms. Liebert actually has included a statement from Dr. Linda Thibodeau, who is Chuck's mom. As it pertains to the criminal charges, Mr. Lacoste was accused by his aunt of using her debit card or bank account without her permission, although they lived together for multiple years, and she permitted him to use her account in a variety of circumstances. He never used it without her permission, but when other family members discovered their arrangement, they became upset and involved the police, believing that their mother had been taken advantage of. After his arrest for theft or exploitation of the infirm, a judge issued a no contact order as a bond condition. Mr. Lacoste never bailed out and therefore was never subject to said bond condition. And when he was accused of violation of a protective order, it was because there were allegedly phone calls made to the alleged victim. No threats, no harm, but a phone call from the jail from Mr. Lacoste to the alleged victim or family member. And that's the extent of the violation of a protective order, which we believe is not a valid charge because there was no protective order in place. There was no court order stating that Mr. Lacoste should not have any contact with a specific person. If there was an order, that order was not served on Mr. Lacoste. Having no notice of said order, he should not have the criminal charge of violation of a protective order. All that also should be, it should be noted that he's innocent until proven guilty, has not been convicted of the new charges against him. And we would ask that this board not revoke his parole on the basis of mere allegations.
What about leaving with his new parole officer without written permission?
Mr. Lacoste, do you want to explain?
May I speak? May I speak now?
Yes.
Mr. Tillis?
Yes.
Okay. Yes, sir. Okay. So I provided to my attorney, first of all, my attorney does have some dates that Ms. Liebert claimed that I was I was away and hadn't gotten written permission to leave, and that I did actually have written permission to leave. My attorney has copies of that in her file, that she had, on some of the dates you read out, said that I had left without written permission when I did have written permission. The other thing, sir, is my father got cancer, okay? And my prior parole officer allowed me to come and go. Yes, sir. And I always worked. I always came back. I never did, as far as any of that's concerned. The thing is that also some of the time now, yes, in fact, I did have a player's card with the casino, but my aunt that I was living with was taking trips to the casino and using my card to get the free play off of it, and so were my parents, and that's why I asked for my parents would say that as well, that they used my card from time to time to get the free play off of it when they would go there. But the other thing was that my attorney also has a copy of my call log to Miss Allison Learett from my cell phone, because she's in possession of that and has been since my arrest. And the thing is that I did try to make contact with Miss Learett, and every time that I did, and she didn't call me back, Miss Learett was out for surgery. She was out for several other things that I didn't know about until later. But in any case, I had also requested Mr. Jason Knockin, who was my prior parole officer, to come to talk to you as well. I mean, about all of this. My father came down with cancer. He's 88 years old. My mother needed help. She's 85. And yes, I tried calling Allison Learett. And yes, I would go to my parents' house. And every time I went to my parents' house, I did work around the house that they could not do, and then came back to take care of going to work here. And so, I mean, I hope I'm answering your question, but I'm trying to give you the explanation. I was not trying to not ask. I was not trying to not follow Miss Learett's request. But when I called for Miss Learett and Miss Learett wouldn't return my phone calls, I don't know what else I was supposed to do, sir. I mean, my father was going through chemo and radiation treatments, and he's, like I said, he's 88 years old, and they needed help. And
So you were not going to the casino?
Mr. Tillis, I did go to the casino, but I didn't go to the casino all that as many times as Miss Learett said I did. And yes, I did. I went to my parents' house, and sometimes my parents would say, hey, let's go get dinner or whatever after I did work around the house. And maybe we went by there once or twice when I went to their house. But I did not go to like I said, this is all coming from information from a player's card and all that. And my parents used the free play that I got from that player's card, and so did my aunt when she would go. And so I'm not saying, Mr. Tillis, that I didn't go, because I did. Yes, sir, I did go, but I didn't go as 10 times or whatever she's got on there that she's saying that I left and went to a casino. That was not what was going on, sir.
Okay, and you said they were supposed to come and verify that? Your aunt and your mother?
Well, my mother would be happy to testify under oath that yes, they've used my player's card. My aunt used my player's card. But the thing is that when they pulled the record from the casino, it showed every time that it was being used. So it was me there, and that was not the case, sir. And on those dates, like I'm saying, my attorney has some permission slips for me to go to Mississippi to my parents that she's accusing me of leaving the state and not having permission. listen, I have no problem, no issue telling you the truth about the fact that, yes, sir, I did do that, but not like that. She's saying I did. Okay, that's not how it happened. And from what I understood, from what I understand, that me having done that, that was a technical violation, not a revocation.
Okay.
I mean,
And if I may add something briefly, Mr. Tillis, Miss Leeret and/or Trina Williams, who participated in the preliminary hearing, did speak with Agent Jason Knockan, and it is in the summary that he provided the following statement. As far as I know, the offender remained in compliance with no reason to violate him for absconding supervision. And his mother, Dr. Linda Thibodeau, also provided a statement and said that her husband Donald was diagnosed with cancer, that Chuck came and he tried to call Allison repeatedly and did not always get a response. And his mother, Dr. Thibodeau, also provided a statement regarding her sister, June, who is the alleged victim of the theft or exploitation of the infirm, indicating that June had never said anything about a financial issue and that she is now listening to her daughter, Shelley, who prompted the criminal investigation. So the witnesses are not present here to testify. In my research in advance of this hearing, I did not find a process for subpoenas, and I apologize, this is my first time handling a parole hearing by Zoom, but certainly Miss Linda Thibodeau and her husband Donald would be present if they were tech savvy or were ordered to be here.
Okay, all right, thank you.
Thank you.
Let's move on to the next violation. Violation number 4, on or about 4/14/25, you were engaged in criminal conduct as evident by your arrest of Terrebonne. Did I read that?
yes, sir, you did read that?
Yeah. And
Sir, I am not guilty. First of all, I am not guilty of violating any protective order because I never had a protective order. And even furthermore, I never spoke to my aunt since I've been arrested. And so I don't even, none of it makes any sense. The judge that set my bond said that if I bonded out, a condition of my bond was a no contact order with my aunt. I got arrested. And furthermore, I got arrested. I did make an attempt to make a phone call to my aunt. I did make an attempt to talk to her, but that was before I'd even been told about the bond, the condition of bond. And so then they said that I violated a protective order and added another $25,000 to the bond. But then I couldn't bond out because Allison put a parole hold on me. And so I never bonded out, sir. I never violated any protective order, sir. I never did. And once someone told me, I never even attempted to call my aunt again. I didn't.
I hear you. Miss Liz, you want to address any of this?
I believe that that Ms. Teresa King has addressed everything very thoroughly. I'm mainly going to defer to her and to Chuck's testimony. The attempted call to his aunt was before he was aware that there was a protective order in place. You don't know what you don't know. And afterwards, he was incredibly diligent. He's always been very diligent, and he was diligent in following the instructions from that protective order. And then just to reiterate, I know that we've passed this issue already, but just to reiterate, even if he went to a casino one time, That is just a technical violation, and as Chuck and the other Miss King have noted, is a technical violation, not a reason to revoke his parole.
Thank you. At this time, I'm going to ask for an executive session, please.
So I'll second. Any objection?
Nope.
All right. Mr. Lacoste will be in executive session for a few moments to discuss confidential matters.
Ms. Renata,
I'll
Ms.
move
Renata,
turn to regular session. It is 9:55 a.m. What did you want to say, Mr. Lacoste?
just to Mr. Tillis. Mr. Tillis, also Ms. Lerat put on that paperwork that I was given that I was in arrears for payments. If you look at the record also, I was always paid 6 months in advance on all of my fees. I never, ever went past due on a fee until I became incarcerated. I am not out. I was not. I was doing everything the way that I should have been doing it, except for the fact that I did go to a casino. And I just would hope that you please take that into account, sir.
All right, I think we're ready to vote. Mr. Tillis?
My vote today is going to be to revoke because of violation number 3.
What is number 3, sir?
Mr. Prater?
I concur, violation number 3, reference to absconding, being out of state.
And I agree, Mr. Lacoste, I've heard everything you said, but you did leave the state without permission, which is a violation of condition number 3. So today, sir, your parole's been revoked. I wish you well on your pending criminal charges. You'll be able, depending on what happens with that, you'll be able to reapply for further consideration by this board. Good luck.
And that was going to be my question. Once his time is calculated, he will be eligible to request early release through parole again, correct?
Yes,
It'll be
that's
at
correct.
it'll be at the discretion of the board after serving a year.
Thank you.
Good morning. Where are we at? How are you this morning?
Fine, how are you?
Good. So we're at East Baton Rouge.
Yes, ma'am.
Would you introduce yourself for the record, please?
Yes, ma'am. Lieutenant Crystal Mayberry.
All right, Lieutenant, thanks for accommodating us. And we have just one case there, Mr. Landry.
Yes,
We're
ma'am.
ready when
Okay.
you are.
Good morning.
Good morning.
Good morning, Mr. Landry. Do you have any paperwork there with you this morning?
No, ma'am.
Okay, we're gonna put a form up on the screen. I want you to tell me if it's your signature at the bottom of the page. It's called a parole revocation questionnaire. You filled it out prior to your preliminary hearing. See, it's come. You see it?
Yes, ma'am.
Is that your signature down at the bottom?
Yes, ma'am.
All right. It was determined at your preliminary hearing based on those questions that you're not eligible for us to appoint you a lawyer today. So you're ready to proceed with that one?
Yes, ma'am.
Okay, good. Your case has been assigned to Mr. Tillis. I'm gonna turn it over to him.
Good morning, Mr. Landry. How are you?
I'm all right, man. How about you?
Good, good. We have two rule violations that were violated. I want to read them to you and you can say guilty, not guilty, or with a statement. Violation number 4, it's alleged that the subject is in violation of the condition in that which he was arrested on 10/29/2025 by the Livingston Parish Sheriff's Office and is being charged with theft, 2 counts, unlawful distribution, and tampering with surveillance. How do you plead?
Not guilty. Those charges were rejected.
Okay, we'll just go through this and then we'll let you talk and elaborate on it. Guilty, not guilty with the statement.
Yes, sir.
Okay. On 12/18/2025, the defendant entered a plea of no contest to the charges: theft under $1,000, theft under $1,000, and resisting an officer. Case 25 MISD 13. The state dismissed the count 1 and count 2. The court accepted the plea of the sentence of the defendant as followed: 49 days parish prison, current with any other time. The court deemed this matter satisfied. Rule number 10, records reflect subject failed to make payments toward monthly supervision fees and currently $882 in the arrear. How do you plead?
I had can I make a statement on it? All right.
Guilty or not guilty? You're saying not guilty with a statement?
Well, I had just came off doing a 90-day tech for that violation, and the resisting that had came. I had got that charge before I ever did the 90-day tech.
Okay.
So had you ever made any payments? Ever?
Yes, ma'am. A couple. I think 2.
Yeah. So you were released in July 1st of 2024. So regardless of the 90-day tech, this says you failed to make any payments ever.
I paid the processing fee.
Okay. Yeah, which is different than a supervision fee. So I get it. I'm sorry.
Well, that's good. Thank you for clearing that up. So you plead guilty or not guilty to the indictment of $882?
I guess guilty with a statement.
Okay, go ahead. Tell us about it.
I had just served a 90-day tech for that violation.
Okay. All right. Any of my colleagues have any questions?
Mr. Landry, you haven't been doing very well on supervision, have you?
No, ma'am.
Why is that?
really drugs. Yes, ma'am.
And I know you've been offered many opportunities to address that issue, and you don't seem to have any interest in doing so.
Yes, ma'am, I do now. I've been thinking about it, and my grandmother, she just got in a wreck. She got her neck. You can ask my parole officer, Mr. Smith. She got a broke neck, and 3 broke ribs, and so it kind of, I guess, been a wake up call for me.
Yeah, I'm sorry to hear that about her. I don't have any questions. I just wanted to hear you talk a little bit about that. I think, are you ready to vote?
Yes, I am.
All right, Mr. Tillis.
My vote today is going to be to revoke for violation number 4.
Mr. Prater.
I concur.
And Mr. Landry, my vote today also is to revoke. I find you guilty of violating condition number 4, the criminal activity. And so today your parole's being revoked, and I do hope that you're able to get some help with your substance abuse issue before you release on your full term date. Good luck to you, sir.
I got to do to my full term date.
Hello, can you hear me?
Hello, Kevin Bochet. Can you hear me?
Yes, I can hear you loud and clear.
Thank you. Very good.
This is Brandon Green.
That's correct. I know him. All right, Brandon, we're up for a parole hearing this morning.
It went back on mute. Went back on mute. It went back on mute.
Mr. Brochet, I think you muted yourself. It would have been.
Can you hear me?
Yes, I can hear you now.
Very good.
Mm-hmm.
Thank you.
We all done, or you need the next person?
Oh.
Oh. Yeah, that's good.
All right, the Committee on Parole is signing in at Orleans Justice Center for revocation proceedings. Today is Thursday, February 5th, 2026, and it's 10:12 a.m. And our first case this morning is Mr. Green. Good morning, sir.
Good morning, ma'am.
Would you introduce yourself? Tell us your name and DOC number.
My name is Brandon Green, DOC number 493822.
All right, sir, thank you. And you have counsel with you this morning. Mr. Boucher, would you introduce yourself, please?
May it please the board, Kevin Boucher, bar number 03286, representing Mr. Brandon Green.
Thank you, sir. And we also have Mr. Green's sister, LeKaiser Green, and she wants to speak. And we'll ask for her remarks shortly. Your case this morning, Mr. Green, has been assigned to Mr. Tillis, so I'll turn it over to him.
Good morning, Mr. Green. How are you?
Good morning, sir. I'm all right. How about yourself?
All right, I'm going to read some violations and you can plead guilty, not guilty, or with a statement. Violation number 4, you failed to restrain from criminal activities. You were arrested on April 8, 2025, Orleans Parish Sheriff's Office. You were charged with possession of a firearm or weapon by a felon and possession of marijuana. The charges are of possession of marijuana less than 14 grams and possession of a firearm weapon by a felon were accepted by the district attorney's office. The charges are set for pretrial conference on 12/9/2025 and trial on 1/20/2026. The subject was found not guilty of possession of a firearm or weapon by a felon. The subject was scheduled for a bench trial on January 26, 26 for possession of marijuana, THC, and chemicals, subject by the schedule, under 14 grams, and an unsafe vehicle violation. The trial has been reset for January 28, 2026. How do you plead? Guilty, not guilty, or with a statement?
Not guilty, sir.
Okay, Mr. Kevin, do you want to elaborate on that?
Certainly. Ms. Lakeisha Green, who's present on Zoom today, will testify, as she testified before the jury of 12 citizens, that she was responsible for placing the firearm in question, that Mr. Green had no knowledge of the firearm, no DNA was found in connection with the firearm to be tied to Mr. Green, and perhaps most importantly, ladies and gentlemen of the board, 12 citizens heard this case and found Mr. Green not guilty in 55 minutes.
Thank you, sir. Rule number 5. You failed to refrain from possessing a firearm as evident by your arrest on 4/8/2025, which you were charged with possession of a firearm or a weapon by a felon. How do you plead, Mr. Green? Mr. Green, did you hear me?
Yes, sir. Not guilty, sir.
Not guilty with a statement?
With the permission of the board, we would incorporate the same statement we just delivered in connection with the previous violation allegation.
Thank you. That's what I thought. Rule number 10, violation number 10. You are in the arrear of $4,725 plus the $65 processing fee. No payment was ever paid as instructed. How do you plead?
I plead guilty, sir.
Okay. I guess at this time, we'd like to hear from your sister by Zoom. Ms. Green?
Good morning.
Lakeisha, tell the board exactly what you told the jury 2 weeks ago.
Okay. The weapon was actually placed in a car by me. It was actually an ex-boyfriend weapon. I was actually returning it to him. I was on my way to go get my hair fixed. I was actually returning it to him. Went to the residence where he was living at. The house was abandoned. He no longer lived there. So I still had possession of the weapon when I went to Brandon's girlfriend's house to get my hair fixed. He actually came in and asked me to use the car. Put in mind, this is my mother's vehicle. We all use the car. He asked me to use the vehicle. Me being distracted, like I said, when I actually got to the house, I actually shoved the gun on the side of the seat, like pushed it all the way under because my mother doesn't have tinted windows. And because the car was parked on the street, I didn't want nobody to see the weapon and break into the car trying to get the weapon. So I shoved it like on the side of the driver's seat, like pushed my hand all the way down and pushed it down. Brandon actually came in around 2, little after 2, and asked to use the car to go get something to eat. I actually gave him the keys, slipped my mind playing in my phone, forgot the gun was actually in the car. I didn't find out that Brandon went to jail until my mama called me. So the gun was actually placed. He had no knowledge. Nobody would have never known that the gun was in there just by getting in the car. You would actually have to search the car in order to, the way I had it shoved, you would actually have to search the car in order to know that a gun was in there. It wasn't visible, so he would have never known or had no idea that it was in there.
Ms. Lakeisha, is that what you told the jury under oath before Judge Pittman on the 21st of January?
Yes, sir.
And is what you're telling this board as you told that jury the truth, the whole truth, and nothing but the truth?
Yes, sir.
Listen to the board. They're going to have some questions for you.
Okay.
Any of the members have any questions for her?
Oh, I don't have any questions of Miss Green.
Okay, thank you, Ms. Green.
Thank you.
Does she have permission to sign off, ladies and gentlemen of the board? Because she wants to go to work at Dollar General.
Sure.
Yes. Thank you.
Thank you. Thank you, Ms. Green.
Mr. Green, what about the drugs that you had? Are you on drugs? You're using drugs?
Sir, the drugs was actually, I didn't have a lot, but I spoke with my parole officer, Miss Virginia, and she recommended me to get, the dispensary card for marijuana, which is on my file. Everything should be in my file for marijuana, but any other drugs, no, sir.
The marijuana in question, ladies and gentlemen of the board, was found inside of a registration form. Ms. Green has indicated the fact that multiple people used the vehicle. It was approximately maybe 1 inch worth of a partial cigarette. It was not a large quantity of marijuana, and that matter is presently set for trial.
Board members have any questions?
I didn't understand what you said about the card. Mr. Green.
Ma'am, is speaking to me?
But yeah, would you tell us again what you said you were advised by your parole officer about the card?
No, not about the car. This way before the car incident. Miss Virginia, who was my parole officer before Miss Tiffany Jones, she had told me that I was dealing with a herniated disc in my back, and she was like, "Well, you can get a medical card for marijuana, and you know, if you want to use marijuana, you can use marijuana, but you got to get a medical card." So I went and got a medical card for the marijuana, but the marijuana that was in the vehicle, I didn't have any knowledge that the marijuana was in that vehicle at all. That marijuana didn't belong to me at all, man.
Okay. Well, let me just advise you that the use of prescription marijuana has to be approved by the board,
That's important.
not by the officer, just FYI.
That's important.
Okay.
Yeah. Okay. Not this all.
Later.
You're gonna have to convince me about the gun because the state trooper says the gun was in plain view, that he could see the extended clip and all of the extended clip portion of the gun, which was a 20 shot extended clip above the driver's seat. Explain to me how that reconciles with what your sister just said.
if I may, Mr. Board Member, sir, I'm trying to read your name, sir, correctly, Mr. I want to pronounce it. Prater, Mr. Prater, thank you, sir. The bottom line is that there was no physical photographs showing that aspect of the weapon. More importantly, I asked specifically about whether or not that gun was tested at all. For they ran a test for DNA on him, but nobody bothered to tie anything at all with respect to the firearm. The clip, there's no photograph of that clip being shown as being visible. That's what I'm trying to drive at, sir. And the evidence that was produced at trial, and again, it wasn't like the jury deliberated very long on this. I just think that needs to be considered.
Consider it.
Any other questions?
I know. I'm ready to vote.
Ready to vote, Mr. Tillman?
Today my vote's gonna be, in violation number 4, possession of, marijuana. And my vote will be, to revoke your parole.
Mr. Prater?
I concur, and I think the gun, it's a he said, she said thing, and I believe that the state trooper saw it. The fact that the DNA, that's irrelevant since it wasn't tested. Revoke it.
All right, and I do agree, Mr. Green. My vote also today is to revoke for the violation of condition number 4. Today, sir, your parole's being revoked. Good luck to you, sir.
So what's the deal, Mr. Boucher?
All right, this is JAIRUS Palmer.
Thank you, Deputy. Mr. Palmer, how are you?
Doing all right. And you?
I'm okay. I'm okay.
See if you can see me, Jairus.
Yeah, here you go.
Hey,
How you been?
good. How you been?
No, me, I'm staying strong here up high. I can complain, but I ain't got no complaints.
Okay.
All right, good morning, Mr. Palmer.
Yes, ma'am. Good morning.
Would you introduce yourself? Tell us your name and DOC number.
My name is Jairus William Palmer, 579-468.
Sir, and you have counsel here today with you. Sir, would you introduce yourself for the record?
Good morning. My name is Krishant Danya.
All right, thank you, sir. Mr. Palmer's case was assigned to Mr. Prater, so I'm just going to turn it over to him.
Okay, Mr. Palmer, you doing okay today?
Yes, sir.
Do you have a waiver form? Do you have a form in front of you that you signed?
Yes, sir.
Okay, and you wanted an attorney, and that's why you've hired an attorney, so you got one here. What is your DOC number?
579-468.
Okay, just wanted to make sure we're talking to the right person. Well, you're here today because you're accused of having violated a couple of conditions of your parole that you agreed to when you got out on parole. One of those is called, what we call number 4. You were involved in criminal conduct. One of them's number 10, says you owe some back money for not paying your fees and fines or your fees for the probation and parole. So we'll start with the first one. And the first one has to do with a domestic violence incident where you were charged with battery of a dating partner on August the 10th of 25. Do you recall that getting arrested for that?
Yes, sir.
Okay. Are you guilty of having committed that? Or are you not guilty? Or are you guilty and you want to tell us why you did it?
I'm not guilty, and with the situation, the state even refused my charges, proving that I'm not guilty.
Okay, so you're not guilty of that. And then, so charges, I understand that the charges were refused by the DA on the October the 7th of 2025. So I understand that, so we don't need to go into a lot of detail about that. And Mr. Attorney, you may interrupt anytime you'd like to say.
Yes.
Is there anything you'd like to say at this particular time?
Not at this particular time, but I do plan to do some talking today, and I would like the opportunity to do that.
Okay. So anyway, so our question, and we understand also, Mr. Palmer, that and you got some folks that are going to speak on your behalf. So Maisha Jackson, did she ever check in with us? So Maisha Jackson, and I hope she does, because she was supposed to be on Zoom, but she has not logged in yet. So we'll move on to your client advocate, Terry Pierce. Is Terry Pierce on?
Yes, sir. Good morning.
Good morning. Would you talk to us for just a brief few minutes and tell us what you got to say?
Yes, I have been visiting Mr. Palmer for several visiting and got to understand that he has been enrolled in Delgado Junior College, and he was working at a detail shop at the time this all occurred. And we have programs that we've been connected to, like New Beginnings behavior programs that will help guys with re-entering into society after being on parole. But Mr. Palmer has been pretty straightforward with me and discussing with me about the situation concerning him and the incident, but I'm gonna let his attorney speak for that. But we have programs for Mr. Palmer, and I think it would be a good thing to allow him to continue pursuing his education at Delgado and into these programs that we have. We have several programs, but the major one that's been really successful is our New Beginnings Behavior and Family Services program. We have been successful in the past with other clients, and I'm sure Mr. Palmer will comply, and it's located right here in this building, and I can communicate with him hands-on personally. Thank you.
Thank you for your support, and thank you for letting us know. Appreciate that. Okay, we'll move on to Diana Johnson, your godmother. Miss Johnson, are you on the Zoom with us?
Yeah.
Okay,
Yes,
tell
I
us
am.
briefly what you got to say about this fella.
Well, I've been knowing Jairus for a very long time, and he have always been, a good guy, really love, just a real good guy. When you be around him, he's laughing, jolly, and all of that. Most of all, I'm here to ask you to grant him whatever he needs, because I believe that he need to be home with his kids. He have kids that he need to take care of as a father. I wouldn't want to see him, locked up and stuff. And he really do need to be home with his kids, because he's a good father. And when you see him with his kids, it's amazing to see how he loves his kids and how he's there for his kids. Sometimes you just don't find that all the time with a young man like him and a father. So just to see him like that, I'm just asking you to give him another chance. I think he needs another chance, and he deserves to be home with his kids, regardless to what happened. I don't totally know the whole story, but I do believe that he need to be home with his kids. It's not like a man being home with his kids. When he got out, he was working. He was trying to take care of his family. And his mom, they've been praying for him, interceding for him, and we've been doing the same. Because I'm a pastor and his mom them is in the ministry, and they've been praying for him as well. So I'm asking you to give him another chance. Let me tell you something. You all did it for my son, and my son right now is doing wonderful. He's in work release, and he's doing wonderful. And it's all because you all gave him another chance. So I'm asking you to give Jairus Palmer another chance. You could see he done grew up to be a great young man.
Ma'am, thank you for your words. We appreciate
You're welcome.
Appreciate your support.
Love
Sure.
you, Jairus.
Does Miss Jackson ever log in?
No.
Okay, Miss Jackson didn't log in, and she was kind of the star witness. I wanted to find out from her. Mr. Palmer, the thing that bothers me the most is that she had a knot, according to the police report, she had a knot on her head. And could we have him back up there, please? There you go. The thing that bothered me the most is that she, according to the police report, had a knot on her head. She had bruising around her neck. She told the officers
Members of the
that
board, may I
the
please cut in?
domestic violence is getting worse, that you will eventually hurt or kill her or her children, and that it's the most that she had ever felt threatened when she was around you. Now, this all occurred, that's what she told the police on the night of the incident, which is August in 2025. Now, I understand she came back and said, no, none of that happened, all, but she did say it, and she did have the knot on her head. So tell me, how do I reconcile that? How do I?
Members of the board, if I may, I think, and I have a lengthier statement to give later, but what I will say just about the allegations themselves. I work at the public defender's office here in New Orleans. It's a great job, but I am noticing a shift in trends where even somebody who says, oh, this didn't happen, the district attorney, when they feel there is requisite evidence, will still continue with the charges if there is the requisite evidence. I think something to delineate in the report is that EMS told the report says that Miss Jackson said EMS told her that there was bruising around the neck. EMS never told the police that there was bruising around the neck, and officers never observed bruising around the neck either. I think another thing to note here is that Miss Jackson had went to his house. This is not a case of Mr. Palmer going to Miss Jackson's house. It was not a case of them cohabitating and a domestic incident occurring. This is a case where Miss Jackson, as she notes in her letter, was incredibly upset. Emotions got very high, and she was looking for an opportunity to get even or harm Mr. Palmer in some way, which she deeply regrets. I don't know the full story of their relationship. The only people who know the full story of their relationship would be Mr. Palmer and Miss Jackson. But what I will say is that if the DA felt that there was a real danger to Miss Jackson, they would have proceeded with these charges. They have, other cases that I have where there is requisite evidence, they do proceed with these charges. It's very rare that they refuse these charges at the jump, whenever there is physical evidence. I don't know what the knot looks like because I never got the body camera. I never got pictures. The report does not have those pictures. Who knows whether the knot came from a child, whether Miss Jackson, while being upset, might have tripped. I wasn't there. But what I will say is that I think it's very powerful that not only did the DA refuse these charges to prevent it from even getting to a place to where these allegations are litigated in court, but then she also came and wrote a notarized letter refuting what happened. I'm going to be honest with you guys. I'm a little nervous talking to you because I've watched a lot of these hearings in preparation for this one. I know what you guys care about. I know that you care that who you let back on parole is somebody who adds to the community, is not a risk to themselves or other people in the community. What I am going to say is that a lot of my friends, a lot of my family members ask, why do I do what I do? How do I represent folks? Do I, it's not for the money. It's not for the respect. It is for the fact of men like Mr. Palmer. I think it's very powerful that Mr. Palmer, after doing what he did to get on parole for, this board saw something in him. This board saw that Mr. Palmer has the ability to add to our community, to add to his neighbors, to have the opportunity for second chances. And I think it's commendable that Mr. Palmer, instead of getting out and committing new crimes, instead of going out and trying to find the easy ways to make money, have worked odd jobs, scraping wherever he can, detailing, cutting grass, doing construction, anything he can do to provide for his children. I think it's, as somebody who grew up needing to always find ways to get educated, I remember through law school, I worked 3 jobs. I relate to Mr. Palmer wanting to better himself by going to Delgado, challenging himself, not wanting to stay in the situation of life that so many other people do. I don't know what happened that day. That's the God's honest truth. I don't know. I don't know whether things were heated. I'm sure they were. But what I will say is that we never had the chance to go through things at trial where I'm sure that we would have gotten acquitted because the DA, the screeners, with all the information, with all the pictures, with all the body camera, saw this case and they decided, this isn't something that happened. This is something that is refuted. And then I think the fact that Miss Jackson, by her own volition, came and wrote a letter saying that this didn't happen, saying that Mr. Palmer is a wonderful father, a caring man, somebody who, regardless of whatever relationship drama they had, is not a threat to me. I think that speaks volumes. I do this job because I believe in second chances, and I believe in the power of people when given the opportunity to better themselves. And I can think of no greater example than men like Mr. Palmer, who every single time I've gotten to visit him, every single time I've gotten to talk to him, his main priority is getting out, not so he can enjoy the life of luxury that somebody who has to work all these jobs has to do, but so he can provide for his children, so he can be the father that prevents his children from making the same mistake that landed him on parole. Because you Google Mr. Palmer's name and you see what he's on parole for, and then you see how far he's come. I'm asking this board to acknowledge the fact that we routinely see people make something of themselves when given the chance.
Okay. All right, thank you, sir. I had a couple more questions. Mr. Palmer, how long have you been in jail?
Since August, 9th.
Okay, that's what I was just making sure that my notes were right. So you've been in jail about 6 months already, hadn't you?
Yes, sir.
Okay, how long have you been on parole?
I've been on parole I came home December 18th of 2024. No, 23, I mean.
Okay. So 2024?
No, December 18th of 23.
23, okay. All right,
Yes,
I thought, and
Also-
during that time, have you been in any trouble during that time?
No, sir. And also inside of the jail, I'm on the honor pod. I don't have no write-ups or no disciplinary actions here either. I'm on 4C, which is an honor pod for good behavior and for workers, but I'm not even working. I just made it up for good behavior and, staying out of the way and enrolling in classes and things. Still
Okay.
finding better ways to better myself.
All right, and I did note as your attorney adequately or whatever put it, that she did come to your house, correct?
Yes, sir.
Okay. All right. I don't have any other questions. I wish she had been on here to talk to us, but I'm okay. I'm ready to vote.
Questions? All right, ready to vote?
Mr. Palmer, you've been in jail for, as I said before, 6 months. Your attorney did a great job of talking to us about you, and you had some good support and all that. And so my vote is to not revoke you this morning. That's my vote. You need some more votes, but my vote's not to revoke you, but you see now how quickly you can get in a bind and be put back in jail when you're on parole. It's almost not fair, but it is fair because you're on parole. So you gotta understand that you gotta avoid the sense of impropriety. Anything to do with, if it even looks bad, get away from it. Okay?
Right,
My
on the clock, at work, 24/7. Out the way, out the streets, home back to my family.
Okay, my vote's not revoke.
Mr. Tillis?
My vote also is not revoke.
And my vote also is do not revoke. So good luck to you, Mr. Palmer.
Thank you all, thank you. That's indeed. I love y'all.
This is Mr. Loyal White. Mr. Terry, you can unmute yourself.
Yes.
Okay.
What's up, Jerry?
Loyal White.
All right, what's that? We gotta wait for them to come on before we start talking, all right?
Okay.
All right. Morning, Mr. White.
Hello, ma'am.
Introduce yourself to us. Tell us your name and DOC number.
My name is Lawyer White, 1034-7.
All right, and you have, your case has been assigned to Mr. Prater, so I'm gonna turn it over to him and he'll recognize your attorney and the other folks who are here today with you.
Yes,
Mr. Prater.
Okay, Mr. White, you doing okay today?
Sir, how you doing, sir?
I'm doing good, sir. Okay, we have some folks that are going to be speaking on your behalf, and we'll get to them in just a little bit. One is New Orleans Public Defender's Office, Shannon Matthew, your niece Stacy White, and Terry Pierce, who is a client advocate. We're here because you are accused of or suspected of having violated certain conditions of your parole. And you have been through one of these hearings before, correct?
Yes, sir.
Okay, do you remember that hearing that you went through, correct?
Yes, sir.
Okay, well, it's the same violations as what we call violations number 4, number 5, and number 10. And basically number 4 is you won't be involved in any criminal activity. You agree to that when you get on parole, and you're accused of having gone to the dollar store and stole some things or attempted to steal some things, and that you armed yourself with a shovel and you kind of fought the guard or not guard, but the clerks. You were arrested for that, correct? You were arrested for it. Is that right?
Yes, I was.
Okay. Were you guilty of those things?
No, sir. I went to trial. I was found not guilty on all charges.
Okay. Well, you were found not guilty of what the DA took you to trial on, the attempted armed robbery. But you understand, we have to deal. We're looking at the video, and we have to determine if there was any criminal conduct at all.
Yes.
So we're not bound. This board is not bound by what the jury said, or we're not bound by what a previous board might have said. So it's kind of like a new day. And I'll let your attorney explain that to you in more detail. And I want to introduce your attorney again and let them say that they can, or let me say that they can interject whatever they would like to. Shannon Matthew, would you like to say anything before we go any further?
Yes, good morning. I've had the honor and privilege of representing Mr. White since his arrest. I have helped him throughout this entire case from start to finish for the jury trial where he was in fact found not guilty. And as the board has read previously, and again, 2 members of that jury wrote a powerful letter in support of Mr. White in acquitting him of wrongdoing in this situation, and to re-urge the ask and the request for Mr. White to re-enter society. And I'm not sure what happened in between the last hearing and this one, but the previous board wanted 2 out of the 3 board members wanted Mr. White to enter into a DOC substance abuse treatment program. I'm not sure what happened if Mr. White was not qualified for the program because he is elderly. He just turned 66 years old in October. And he's had several medical conditions, which he takes medication for. But I also recently found out that the DOC program at Bossier Correctional Center, they do take people with sex offender status into their program and put them on the wait list. I just found this out yesterday, and I apologize that that's on me for not reaching out to them to see why Mr. White wasn't on the wait list or wasn't enrolled in their program. However, if he's in fact qualified for that program, he is willing and he's able to do it. In this time since the last parole board hearing to now, he has tried and done programs at OJC for substance use programming, where he is involved and he has a case manager there as well. In the event, Mr. White, because of his elderly status and his medical conditions, he was screened by Cotton Brook Grove Recovery Program and Reentry Program. The director actually went to OJC and screened him in person, talked to him, knew of his status. I understand that at the last hearing, there was a question as to whether the program that we had reached out to would allow Mr. White into their program because of his sex offender status. And this is now delineated with the Cotton Brook program, where they know his status. They're able to continue him with his registration requirements and everything that he needs to do for parole with his parole officer. Their residence, to my understanding, has already been with previous parolees and probationers to have been approved of their residence. I understand that before there was there has to be an investigation as to the residence to see if it qualifies for Mr. White to be in that residence and if it qualifies for their programming. Mr. White, from the beginning, and even before his arrest, even while struggling with substance use, he had been checking in regularly with Detective Henry, with his parole officer, Mr. Wilder. Mr. Wilder, during the preliminary hearing last year, said, Mr. White was checking in, that I told him that what he uses for disability, that the fees can go towards his medications and what he needs instead of the fees for the sex offender registration. And so Mr. White was up and honest with them. He was up and honest with the officers who arrested him. Instead of running away, Mr. White stayed. And I think that's so powerful, because a lot of the times we see when someone is accused of wrongdoing, they immediately run away, they resist. And Mr. White, as soon as officers arrested him, handcuffed him, he didn't fight them. He talked to them. He said, you know what? I do have a pipe in my pocket and I did use before. And a lot of the times we see people who, especially when they struggle with substance use, that they don't acknowledge that they refuse to acknowledge their struggle. And Mr. White has consistently acknowledged that.
Okay. All right. Well, I appreciate that. And just so you'll know, our records reflected that he didn't go to Bossier because of medical problems, not because of the sex offender status. He didn't go to the last housing place because of the sex offender status. But I read about the new housing thing. I think Mr. Pierce's letter or yours. I read all about that and researched that on the internet also to see what kind of facility it was. And they do take sex offenders there. So I think it's pretty simple. I'd like to hear from since she is here on Zoom, Miss Stacy White. I'd like to hear from you next. Is Miss White on Zoom?
Mr. Young.
Good morning, board members. I am here.
Yes, ma'am. Would you tell us briefly, I think we know a lot of the background about him and all that. So you tell us briefly what you have to say, please, ma'am?
Could could I tell you briefly on what again, please?
On what you have to tell us about this fella and your relationship with him.
Okay, that is my mom's brother, and we were honored that he got paroled back in 2019. And from then, we paid all of his sex offenders' fees. We were current with everything because that was his first time out, and everything was a success. And upon my mom's passing and just him trying to adapt to society, he fell victim to his addiction, not having set up his Social Security at that time. He didn't have any, like Social Security would offer him to have counseling and different things like that. He only had me, and we also paid for his parole to get him here in Texas by me. So it was only so much he can do with the support that he had in Louisiana. And once my mom passed, that brought him on a dark path of grieving and where he led to something that I was surprised of myself of finding out he was on drugs. So I'm still here with him, and I'm also in touch with Lisa Carey, who also helps sex offenders with housing because that's the program that he was in 2019. I also have another guy with a sex offender program that he was in before he wind up homeless because he was overwhelmed with grief. His addiction took over him, just not having the proper treatment that he needed, on top of his whole check at the time just going towards bills and rent. Because I think it was like $750 a month that he was paying. Because I assist him much as possible, trying to encourage him, help him in any way possible. And like I said, we were successful at paying the sex offender fees in full back in 2019. But by him moving, that made us have to, if he moved, he have to go through more fees. And right now with the economy, we weren't able to afford that. But upon his release, if that's possible by the board, we actually have him somewhere to stay that's affordable. I also have connections with counseling to get him in treatment 3 times a week. And I will be there personally next week, or just to be there for him as always, to make sure he's connected with what he needs to help get more adjusted to society with his grieving, with his addiction. I'm grateful for the people I've been in touch with the past couple of weeks to make sure he has a successful release this time as he's aging and everything. So I'm here as a support from day one.
Okay, and Ms. White, are you referring, when you talk about a place to live and all that, are you referring to the same place that we've discussed already this morning? That the let's see,
Attorney.
Yes, that Shannon Matthew mentioned. Is it that same place or is it a different place?
It's 2 different locations that he lived in 2019, and another one he lived in New Orleans East. I believe that was in.
Let me interrupt you just a second. I'm talking about when and if he's released, where are you talking about he's going to live?
Well, I'm familiar with what Shannon Matthews is referring to because they were trying to release him to Baton Rouge. But if he is released into Louisiana, he has 2 places, one in Marrero, Louisiana, and one place in New Orleans East, Louisiana, that I'm connected with to get him, that has taken him in the past, and the parole officer has approved.
Okay. All right, let's hear from, thank you for those comments and we appreciate all of your support that you've been willing to give to him and that you have previously given to Mr. White. Mr. Terry Pierce, would you talk to us a little bit about, maybe you can kind of put this together for us a little bit?
Yes, sir. Thank you. I appreciate being able to talk and help Mr. White out. Mr. White has been incarcerated approximately 14 months now over this incident that occurred. And I've been knowing Mr. White for many years. Mr. White is not criminalizing out here in the streets. He got hung up in a situation where he was you know, going through things like Miss Stacy said, and I think she said enough. Mr. White has health issues, and right now he's really a liability to the state, being incarcerated. I think it would be a great idea to let Mr. White have another chance at being home with his family, since his niece is willing to come by and help him. And we also, like I say, Cotton Brook Cove is a reentry program. Mr. White has been in the programs inside of OJC with Mr. Dwayne Parker program, working on drug situations. And we have programs out here, and I will help Mr. White personally, since he's also someone I know personally. And the other program in Baton Rouge, I talked to Mr. Frucell, the director over Breaking Chains, and he expressed to me that they are completely full. They don't even have any bed space. The last board recommended he go to a program inside of the Department of Correction for 6 months, and after that be sent to Breaking Chains. But Breaking Chains no longer have any bed space. Mr. White has been punished enough, I think, sir, board members, and we would appreciate it if y'all allow him to be released to his only family member he has. Thank you.
Thank you, sir. Thanks for your support and what you do, being supportive of everyone. Okay, Mr. White, let me talk to you again. We kind of short-circuited what we were talking about, and of course, you were arrested for that, then you were found you were found not guilty of what the DA charged you with, but it was apparent that you were involved. It was apparent to me that you were involved in some criminal activity in stealing and trying to leave the store with it. But we're not here, but we are here to talk about that. But we're also here because I want to honor what the previous board determined and honor what everyone else. We want to do what's best for you, but we have to balance that with what's best for society and the safety of society. So that's where we find ourselves right now, trying to do the right thing. I kind of need a lifeline here, board. Do y'all have any questions that you want to ask him?
No, I don't have any.
So I have just to mention, I thought that, and I saw in the record that Breaking Chains did not accept him because of his status as a sex offender.
And so
Not that
I
they-
can,
Go ahead.
oh, sorry. I can clarify. So Breaking Chains did accept him, even with his sex offender registration. However, now, as Mr. Pierce said, that the availability for beds is no longer available. The beds are full at Breaking Chains. What the alternative that we've come up with is this Cotton Brook Cove recovery program. It's a structured environment specifically dedicated to people with sex offender status and medical conditions. And they also have access to drug treatment programs. So when someone is struggling with substance use, they fast track it. They and it's immediately addressed, especially in Mr. White's situation, where he's dealing with these three situations, right? Drug treatment, sex offender status, and his medical conditions. And they can attack all three things in their program, and it's already been approved previously. And so the director has indicated that he can, as soon as, and if you can have mercy on Mr. White to release him to this program and make it a condition of his parole that he stay in this program and attack all of these three situations that he has.
Thank you. I do, just for clarification for the record, I do see that Probation Pro did speak to Breaking Chains a few days ago, and they advised that it was It was not disclosed to them, and this is the program administrator, I guess, that he has a sex offense conviction and they don't accept sex offenders. So that's what we have, why they did not accept him. It says their program does not accept sex offenders. So just for clarification and for your future reference,
Thank
they do
you.
not accept sex offenders. That's all the questions or comments. that I
She's
have.
saying that,
That, not the new program. This is the one they rejected.
okay.
And I apologize.
I don't have any other questions.
Was there an out-of-state plan for him at any time? I think his niece indicated Texas.
Yes, ma'am. Thank you for allowing me to speak. Yes, we paid for his interstate commerce to transfer here by me. And upon when talking with the parole lady here in Dallas, Texas, where I reside, she mentioned that although he's a low-level sex offender, it's still the condition of him living by a school. So the school was like 100 feet from me or so. And so, and that's what stopped him from coming here by me, because I can completely support him and keep him on the right track.
So he
And that's
never
why,
got there. Okay, I thought he never got to Texas.
no, we just have the money just sitting there after we pay for it.
See, I just thought maybe that he was there and then he left and came back, but he never got there.
No, due to the parole, talking with the parole lady here in Texas, after like I said, that to me, that was the best thing for him. But we had to learn all these other things about him, you know.
Yeah, there's restrictions.
Okay, I'd like to ask for excuse me, through the.
I'm done.
I'd like that executive section.
I second.
We have a motion and second for executive session. I also, I do not object, so we'll be in executive session for a few minutes to discuss confidential matters. All right, Mr. White, I'll make the motion that we go back in regular session. Is there any objection?
I'll second.
We have a second and no objection, so we are back in regular session. It's 11:25, and I think, Mr. White, we're prepared to vote. Mr. Prater?
Okay, before I vote, Ms. Matthews or Mr. Pierce, is Cotton Brook Cove, is it a program or is it just a living facility?
And Mr. Pierce is on mute, but
It's
I believe
excuse me. It's a program. It's a reentry program that's been designed, and Miss Danielle Murray she can elaborate more if she say if you need any more information you can call. But it's a program. It's a reentry program, just like the First 72 and other programs they have around in the Orleans area. It's not as much as one like the parole project, but it is a program they have counselors and all sorts of hands-on, support over there. It's in Marrero.
And are you gonna still be involved in it yourself?
Yes, I'll be personally involved with it with Mr. White for sure.
Okay. All right, well, my vote is is it in lieu?
Do not. Enhance.
Do not revoke and have him assigned to or to go to the Cotton Brook Cove for treatment of his current challenges.
Mr. Tillis?
I concur with Mr. Prater.
My vote is the same. Do not revoke with the added special condition that he go to the Cotton Brook Cove for his treatment and that he stay connected with the Orleans Public Defender or the client advocate, Mr. Pierce. Stay connected with him.
Thank you so much.
Mr. White,
Ma'am?
you understand?
Yes, ma'am.
All right, good luck to you, sir.
Thank y'all. Appreciate it. Yes, yes, yes.
Hello, this is Mr. Brandon Winston.
Good morning, sir.
Good morning, yeah.
And you are you, what's your name, sir?
Brandon Winston,
And what's your DOC number?
554-877.
And when you had your preliminary hearing, sir, you were determined that you wasn't eligible for an appointed lawyer. You ready to proceed today?
Yes.
Yes? Well, Mr. Prater is going to take the lead on your case.
Okay, Mr. Winston, you doing okay, huh?
Yes, I'm doing fine.
Okay. When you get paroled, you agree to certain conditions. One of these conditions, and you're not going to do criminal conduct, and you're not going to be around guns and things like that. And today you're charged with having violated that condition. That's what I say charged with. That's what you're accused of, because you were arrested in July of 2025 for possession of a firearm by a convicted felon. And it was during the process of you doing burnouts in the parking lot.
No, I wasn't doing burnouts in the parking lot.
Excuse me, sir, what'd you say?
I wasn't doing burnouts in the parking lot, and the gun was for my friend that was in the car with me. I never had the gun.
Okay, so you're saying you're not guilty of that. Were you driving and doing the burnouts?
I was driving, but I did like a 1 second burnout because they had somebody walking on the sidewalk. He told me to show him some of my car, so I hit the gas, and then the police just came from nowhere and took both of us out the car. They took me straight into the police station. They left him in the car. They took him out the car, and he had the gun on him on the passenger side of the car.
Okay, and I do want to say for the record that the DA refused the charges of a felon in possession of a firearm. All right. But that, you understand, that doesn't really excuse the fact that you're hanging around with people that are carrying guns.
The whole time I didn't know. I had zero knowledge that he had a gun on him. He never showed me a gun. I never seen the gun. He just got in the car. He never showed me a gun. He never told me he had a gun.
But he got in the car. He got in the car and he put the gun in the side pocket of your.
No, it was nighttime, and the car is dark at night, so we was just riding around. I never knew he had a gun in the car. The whole time.
And how many people were on the parking lot watching y'all do burnouts?
We wasn't. It wasn't a parking lot. It was a street. It was like they had people walking up the sidewalk. So I wasn't doing like donuts. So I did like a 1 second burnout. And then 2 police came from nowhere and took us out the car.
Okay.
I wasn't doing that. And the person that had the gun, he's not even a criminal. So he's not even a convicted felon.
Say that again.
I said he's not even a convicted felon. He brought his girlfriend's gun, and he didn't even tell me that he had the gun on him the whole time.
Right.
So if I knew he had a gun on him, I wouldn't even did no kind of burn off or none of that stuff.
Okay. How long you been on parole?
Since 2016. I never got in trouble not one time, and I have a job. I work at Coca-Cola 6 days a week. I only have 1 day off.
Okay.
And I passed all my drug tests, and I never got in trouble.
Well, that's pretty impressive. Can you go back to work for Coca-Cola?
Yes. You're waiting on me.
Okay. All right. I don't have questions.
Any questions?
No.
Okay. My vote today, Mr. Winston, is with a stern warning. Be careful of who gets in your car and don't be doing burnouts. That's so stupid.
I know. See, I didn't think we had anything in the car. I thought the police was just going to give me a ticket. That's what I thought. When he came up to the car, and I just let him in. But I got you. I ain't gonna do that no more.
Okay, well, you're gonna be getting out in 3 months anyway, but my vote, and I only got 1 vote, but my vote is to not revoke you.
All right.
Let you out.
Okay, thanks.
Did you tell us?
My vote also is do not revoke.
Okay, my vote also is do not vote. See how easy it is to get in trouble. You go.
Yeah, I've been here 7 months. I've been here 7 months.